good evening. Welcome. This is Hot Edition. We're live from Manisa Bata, Desawe Kanda. Also live on Kesmi 107.1 in Tamale and beyond. We're live on W93.5 in Wa and beyond. This evening here on Hot Edition on 3FM 92.7. The news that we have been following quite closely every step of the way here on Hot Edition on 3FM 92.7. Also on 3news.com. If you're just new to it, welcome. The fate of the Chief Justice Gertrude Isabatukono hangs in a balance as President Mahama sets up a 5-member committee to hear petitions seeking her removal following her suspension today. We've got details for you here on Hot Edition on 3FM 92.7.
Well, I'm not able to disclose details of the process. As you yourself may know, there are strict rules of confidentiality. But I can tell you that such a conclusion has been reached, and it is on the basis of that the president has taken a step that I have just announced.
Well, we'll get details of that, plus a lot of reactions to this latest development. Stay with us here on Hot Edition on 3FM 92.7. You would hear from the Minister in charge of Government Communications, Phyllis Kwachofos, who's going to be joining us. We'll have a conversation, and also private legal practitioner Martin Pebo, who's also waded into this Akonta mining development and challenging the revocation of their mining license in court, accusing government of playing politics with the matter. Meanwhile, President mounts on authorities to arrest and prosecute directors and agents of Akonta mining. Yes, Martin Pebo on the matter.
We commend Amma Kufibua, Minister for Lands and Natural Resources, to, and encourage him to go the 9 yards, make sure that the investigations lead to a criminal prosecution.
We've got details for you also this evening. Inspector General Police Christian Tete Yohuno reshuffles 34 police commanders from Galamsey endemic areas as effort to clamp down on illegal mining. Stay with us. We've got some reactions on this particular one as well here on Hot Edition on 3FM 92.7, also on Kesmi 107.1 in Tamale. We're live on W93.5 in YMB. On earlier today, the health minister made a surprise visit to the Tamale Teaching Hospital over negligence claims, and we'll tell you exactly how it all played out there. The President John Dramani Mahama has also been offering 1,000 ECOWAS scholarships as from the country of Ghana. Stay with us with the latest in business and sports for the next 1 hour 30 minutes here on Hot Edition on 3FM 92.7. Safa Bahin is here with a summary of the news.
Thank you, Alfred, and welcome to the news summary segment. Let's begin with one of the stories that has got people talking and reacting to it for the past 2 hours now, and following the determination of a prima facie case in the 3 petitions asking for the removal from office of Chief Justice Gertrude Isabatukono. President John Dramani Mahama has suspended her and set up a 5-member committee to inquire into the petitions. Away from that, the Ghana Catholic Bishops' Conference, following the death of Pope Francis, has urged the church in Ghana to pray and prepare hearts for the election of his successor. In a statement, the Most Reverend Matthew Kwesi Jemfi, the Catholic Bishop of Sunyani and President of the Ghana Catholic Bishops' Conference, asked for prayers as the church mourns, saying that our beloved Holy Father, and as we prepare our hearts for the election of his successor. Away from that, too, a task force from the Tema Development Company, TDC Ghana, with support from a national security team on Monday morning, stormed the Sakumono Ramsar site and demolished illegal structures. The managing director of TDC Ghana Limited, Courage Nunek Peku, told the press that the emolution exercise was part of efforts to reclaim encroached state lands and also protect Ramsar site from further encroachment. Now, away from that, DHL Express is suspending deliveries to the U.S. worth more than $800 because of a significant increase in red tape at customs following the introduction of President Donald Trump's new tariff regime. The delivery giant said it will temporarily stop shipments to American consumers on Monday until further notice. Now to our last story. For the last few weeks, many foreign students living in the U.S. have watched as a sequence of events has repeated itself on their social media feeds. Plainclothes agents appearing unannounced and hauling students off in unmarked cars to detention centers. We'll definitely be keeping a close eye on that. But this is where we end our news summary segment. And over to you, Alfred.
Thank you very much. So far by here this morning is on 3 News. 3fmnews.com. This is Hot Edition on 3FM 92.7. Straight into the issues right now, as the fate of the Chief Justice Gertrude Arba Esaba Saki Tukunum now hangs in a balance following the decision by President John Dramani Mahama to suspend her from office. The Chief Justice's interdiction follows the establishment of a prima facie case in 3 petitions seeking the removal of Madam Tukunum and the subsequent setting up of a committee to inquire into the said petitions. We've got in studio Dennis Paperu, Adam Esquire, and Dennis. Look, we've been on this part for quite a while now. The first time this particular matter became public as to the 3 petitions against the Chief Justice, when the statement was issued by Phyllis Kwachofosu giving us that particular indication, you had mentioned as part of Article 146 a number of options and how the steps will play out as from then till now. It's been almost a month now that this particular issue has been playing out since that first announcement, clearly indicating Article 146(10)(a). This is what has been activated now, is it not?
Precisely so. And Alfred, I mean, even last week we had reason to clarify some things that needed to be done before a possible suspension, because the conversation out there already was to the effect that there was a suspension. And just to set the record straight, at the time, we did indicate that per the provisions of Article 146(10), certain things needed to have been done before any suspension could have been activated. So we were clear in our minds that we hadn't gotten there yet. Because, of course, when you look at the construction of Article 146(10), it talks about the fact that there has to be in place a committee, and even before that committee will be set up, it meant that the President, in consultation with the Council of State, ought to have found a prima facie case against her. As at the time, we had not got any indication as to the confirmation of that. Talk less of the setting up of the committee and then a subsequent submission. But as we speak now, all those things have come to pass. It is now clear that a prima facie case has been found against the Chief Justice. A committee has been set. The petition has been referred to the committee the petitions have been referred to the committee to look into same, and then she has subsequently been suspended as being the Chief Justice of the Republic of Ghana, Alfred.
And as per the details of 146(10), as you did indicate earlier with that education that we got from you, the details of the prima facie so established, we will have to get to know, is it not? It has to be made public.
Well, so the provision is that, the law regarding all this is that all these things are supposed to be in camera. Yes, we will be told as and when major milestones are made. For instance, the referral of the petition that we were told, when the petitions were referred to the Chief Justice for her input or response, whichever way you want to put it, we were also informed. Now that she's also been suspended and the fact that a committee has been put together in consonance with Article 146, we have also been informed. Because mind you, the Chief Justice is not only the leader of the Supreme Court, she's also the administrative head of the judiciary. And to that extent, she is the leader of the Judicial Service. So if the head of the Judicial Service is suspended, we all as public do engage with the Judicial Service, so we have to know about that particular occurrence. So yes, we have to know, but as to the content of the petition, the responses, and all that constitute the proceedings of this particular engagement, all has to be in camera, at least. That's what the law says, to protect the sanctity of it. And that's why, when you look at a letter that was written from the presidency to the Chief Justice, the presidency was quite worried that some portions of the petitions were in the public, and they had indicated that they had to mark some of all the pages of that of the documents that were sent to the Chief Justice, just to ensure the sanctity of the process and that they do not get leaked. But this is a new world altogether. As hard as they try to keep the things in place, some snippets of information still keep slipping out, which are purported to be excerpts of the petition. Because as the law says, we are not allowed to get into the details of the petition. In fact, we are deemed not to even know what the content of the petition is. And that's how come you do not see some of those communications coming out of. If not, you would have seen the presidency quote at length what the exact allegations are against the Chief Justice and what possibly her responses are and all that. But we are not seeing that because of what the law says when it comes to such proceedings, Alfred.
But let's get into the composition of this committee that has been now established as per the dictates of Article 146 of the 1992 Constitution. Who are on this committee and exactly what are the portfolios of these persons?
Well, so As the law requires under Article 1466, it requires that the composition of this committee should be a 5-member committee, 2 of whom should be justices of the Supreme Court, then some other 3 persons who should not be members of the Council of State, they should not be lawyers. So as we have it, the statement from the presidency did indicate that this committee now is being chaired by Justice Gabriel Scott Palmer, who is a justice of the Supreme Court. The second person who is a member of this is Justice Samuel Kwame Adibu Eseidu, Justice of the Supreme Court. We have Daniel Yao Domelevu, who is the former Auditor General of the Republic of Ghana. We have Major Flora Banwarinu Dalugu, who is a member of the Ghana Armed Forces. We have Professor James Sefa Jifa, who is an associate professor at the University of Ghana. This is a 5-member committee that has been composed to look into this particular matter, Alfred.
I see. And what exactly, and as per the details of 146, will be the mandate and responsibility of this committee?
Well, so it simply states that this committee is supposed to make inquiry into the petition. Now that a prima facie case has been made, it simply means that there is something in the petitions that the Chief Justice has to respond to, or there's something that links her to the petitions or allegations raised in the petitions for which she must answer. So essentially what this committee is supposed to do is to look into the merit of that and then make recommendations to the president as to what next to do. That recommendation, we understand by law, the president is bound by same. However, while this process is ongoing, then the president has the opportunity to trigger Article 146.10, which we spoke at length about, which has to do with the suspension, which the president has actually exercised by way of doing so. However, Alfred, it's also important to note that 146.11 is also another provision that we need to pay attention to, because that also allows the president to revoke this suspension at any time. So it essentially means that even though the suspension has been done already now, any moment between now till the end of the proceedings, if the president deems it fit, he can revoke that suspension as well.
In revoking it, that would be obviously not in oblivion. It has to be predicated on something, isn't it?
Well, so it doesn't specify exactly what it should be predicated on. As long as there's a suspension, it also gives the president the opportunity to revoke if he deems it fit. So these largely are discretionary matters within the purview of the president, and if he wants to exercise same, just as he has exercised the power to suspend, he also has that power to exercise if he wants to revoke that particular suspension.
I recall that when this injunction cases against this entire process was called again sometime last week, there has been a second adjournment. But I recall after that hearing that led to the adjournment last week, the former or immediate past Attorney General Godfrey Yeboah was making the point forcefully that in his view, the entire process should have been halted until the determination of the injunction cases against the process. The Attorney General, the learned Attorney General, Dominic Ayene, held a different view, that the president is only undertaking a constitutional duty. I mean, with this development right now, what becomes of those 2 petitions running as we speak at the Supreme Court?
Well, so as the practice would be, the parties would still have to appear before the court. Those are matters that the court itself would determine as to whether they would want to take a move to suspend the processes that are already in progress, or the processes that are already running. That is, whether to suspend or to injunct the president from carrying through what's already in motion, or to allow the president to go through with it. I mean, the former Attorney General is lawyer for the plaintiff and applicants in the matter of the injunction process. So you can understand where he is coming from, because they have gone to court essentially to stop the process and to hold the process. So, I mean, it is convenient for them to make an argument to say that ordinarily the process should be halted. The Attorney General on the other side is opposed to that. So it's also okay for them to argue that no, the president is performing an executive function. And I mean, truthfully, the courts are hesitant when it comes to injuncting presidents when they are performing their duties. So he made the argument clearly that no, for him, he does not think that it is a good argument to say that the president should stop whatever process is ongoing by virtue of just filing an injunction application. But also think about it, just as a layman, that if by virtue of filing an injunction application should stop the president, you can imagine how many people will go to court just to file injunction applications pending their hearing, meaning that government cannot run. I mean, but all those are things that will come to play for parties to make their arguments and also to aid the court in coming to a conclusion whether or not to grant such an application or not. But of course, there's also a substantive matter to be heard as to exactly whether or not the president is obliged or is an obligation in law to give a chief justice who has been petitioned against an opportunity to respond, so that such response will form part of the consultation that the president will have with the Council of State in coming to a prima facie case or not, and if so, how many days should such a thing be done? Should it be done before or after, and all those things? If the court deems it fit to go into the matter, they will certainly do so. If they, on the other side, do not think that it is a matter worth pursuing, they could just strike it out as moot, if depending on the circumstances. So we look forward to that 6th May hearing, if only it will come on.
Certainly so. And just for the uninitiated, there's a press statement that was issued moments ago, earlier this afternoon, by the Minister for Government Communications, Phyllis Kwatiofosu, the Sebu Member of Parliament, stated that in consultation with the Council of State, there has been a determination of a prima facie case in respect of the 3 petitions against the Chief Justice, Justice Sabatukono. The Minister, a while ago, spoke to my colleague Eric Maonek, but I'm going to put portions of this statement on the screen on Facebook right now, essentially detailing the reason why this suspension has been, as it were, acted upon by the president in activating Article 146(10)A of the 1992 Constitution of the Republic of Ghana. This is what Phyllis Kwatiofosu said earlier.
I'm not able to disclose details of the process. As you yourself may know, there are strict rules of confidentiality. But I can tell you that such a conclusion has been reached, and it is on the basis of that the president has taken the step that I have just announced.
And so, amongst many other things, one question that's being asked is, this statement you issued is silent on who takes over now that the president has suspended the Chief Justice. What's the expectation of the president?
Well, the judiciary is a well-established institution in our country. They have their own administrative processes for getting someone to act in the stead of the Chief Justice in the event that she is temporarily unavailable. That is not a matter that the president determines. It is for the judiciary to make their own arrangements.
First ever of such a decision we've seen happen under any republic outside of the first ever president the country had when he removed the Chief Justice. What sort of processes went through this arrival at this decision? Because many are curious as to why we're seeing this happen for the first time and under John Mahama.
Well, the processes are clearly outlined in Article 146 of the 1992 Constitution. Indeed, you only have to read the statement I put out to appreciate the steps that have been taken. You recall that some weeks back, I informed the nation on behalf of the president that he has received petitions from 3 different quarters alleging various forms of wrongdoing against the Chief Justice and demanding her removal from office. Upon receipt of that, and in strict conformity with the dictates of the Constitution, President Mahama began a consultation process with the Council of State, which consultation process required that he, in consultation with the Council of State, determine whether there was any basis to proceed, i.e., determine whether there was prima facie warranting any further steps as prescribed by the Constitution. So you recall that he forwarded the petition to the Chief Justice in consultation with the Council of State and requested her to provide responses in order to enable an assessment as to whether or not some prima facie exists on the face of the petition. This was complied with by the Chief Justice, and the President continued the consultation process with the Council of State. And the outcome of that consultation was that prima facie has been determined in respect of all 3 petitions. This also then means that Article 146(6) of the Constitution must kick in, which then requires the president, in consultation once again with the Council of State, to set up a 5-member committee whose composition is contained in the statement I just issued. That membership of the committee is such that 2 of the members must be justices of the Supreme Court,
right?
One of whom will chair the committee, and 3 other individuals who are neither lawyers nor members of the Council of State. And so you find that the 3 others who have been named meet this criteria. They are not lawyers, they are also not members of the Council of State. Once that is done, the petitions will then have to be referred to the committee to inquire into as to whether or not there is a basis to remove the Chief Justice from office. Now, while the committee does its work, and once it has been set up, Article 146(10) of the Constitution empowers the President to suspend the Chief Justice for the duration of the work of the committee up until such time that they make recommendations to the President on what further step to take. So you find that everything the President has done has been grounded in the Constitution, Article 146, and its various provisions. So if you ask me about the process, this is exactly what has transpired since the tendency of these petitions.
All well and good, these processes you've outlined, but one criticism which is coming strongly from the quarters of the opposition NPP is that you're abusing these laid down processes in Article 146, and what we've seen happen up until this point is an attack on the country's judiciary.
Well, first of all, the NPP has come in for criticism for their unwarranted politicization of this particular issue. It is curious that it is a political party, the New Patriotic Party, that appears to be up in arms about this. Otherwise, every reasonable person understands exactly what is happening. That the President is required to act in specific ways once he receives this petition. In fact, before President Rama took office, in the dying embers of the Akufo-Addo administration, a similar petition went to the President, and he took the same steps that the President has taken, except, of course, the determination of a prima facie. President Akufo-Addo also went into some consultation with the Council of State to determine whether there was prima facie in that petition. He, on that occasion, said there was no basis to proceed further. President Rama, on this occasion, believes that in consultation with the Council of State, prima facie has been determined. So it is not clear why the NPP believes that when they are in power, their president can act in accordance with the Constitution. But when they leave power, another party that comes to power cannot act in accordance with the Constitution. So one has to question the sincerity that they bring to this whole discourse and question whether or not it is not politically motivated. Because quite frankly, they have not covered themselves in glory in this particular matter. They have needlessly politicized this and created an impression that the Chief Justice is one of them and she's been handed. And it is manifestly unfair to the Chief Justice what the MPP is doing. Their claims also do not hold merit because they cannot point to a single infraction on the part of the President in this whole process. And I'm not sure why they continue on the tangent that they are going. What has simply happened, and I must stress, that the President has not said that the Chief Justice is guilty of any offense. The President has only said that when he consulted with the Council of State and looked into the petitions and weighed them against the Chief Justice's responses, it became clear that there are further questions that need some answers. The platform to do that is spelled out clearly by the Constitution, and the President has followed that particular stipulation to ensure that the matter is determined conclusively, but it is determined by persons who are clothed with the mandate to do so, which is the committee that he has set up. So, again, I must express my surprise about the conduct of the New Patriotic Party in this instance. One can only infer political motives to what they are doing.
Just final question from me in relation to this 5 members we're seeing, senior most, second most, senior most at the Supreme Court, and then the membership. We see a security person, we see an auditor, a former auditor general as well, and then a person from academia. Is this leaning into the details captured in these petitions, which is forcing the President to toe the line in the individuals, the non-members from the Supreme Court, which were seen on this 5-member committee?
Well, the rules governing this process are pretty strict and stringent. One is not permitted to make any disclosures in respect of the details of the petition. It is only the President, the Council of States, the petitioners themselves, the Chief Justice, who natural justice demands is giving copies of the petitions, and the committee that has been set up who are seized with the petitions. No one else has a right or authority the details of this petition. So, regrettably, I'm unable to answer your question as to whether or not it is the nature of the petition that has necessitated the selection of the individuals who have been selected.
Right.
That if I were to go into the mind of the president, I believe that he thinks that these are the individuals who have what it takes to unravel the facts surrounding this petition, whether or not there is even any basis to remove the Chief Justice.
President Felix, I appreciate that you could join us.
Well, so that's Felix Kwachofo. So there is the Minister in charge of Government Communications talking to my colleague Eric Mayona Egbeta, giving some details there, essentially making the point, and then is that the Chief Justice indeed responded to the petitions, but then again, looking at her responses, there's some further and better particulars needed. Reason why this committee has been established, and essentially she's been asked to in fact, she's been suspended while this committee does its work.
Precisely so, because it has also been and it has always been the Chief Justice's argument that, you know, she actually wrote to request to be given the petitions to respond to same, because her argument is that her responses, together with the content of the petition, will form the basis for the consultation between the President and the Council of State, on which they will come to a determination whether or not a prima facie case has been made. So, based on her responses, together with the content of the petitions, they've been able to come to that conclusion to make a determination of a prima facie case. But Alfred, what is obviously missing from the statement, for which many are asking, is the question of, now we have our Chief Justice suspended, who then is the Chief Justice of the Republic of Ghana as it stands now? Obviously, we don't have a Chief Justice as it stands now. However, somebody would step in to act as that Chief Justice.
And I heard Felix Kwachofo also talk about the fact that there's already a process that within the judiciary to have somebody act. It doesn't necessarily have to be President Mahama naming an acting Chief Justice, essentially.
Well, that's what he says. But when you look at the Constitution, there's actually a provision, or the Constitution contemplates a situation whereby a Chief Justice may be unavailable to perform his duties, and under such circumstances, it spells out clearly what should be done. So when you look at Article 1446 of the 1992 Constitution, it reads as follows. 6. Where the office of the Chief Justice is vacant, or where the Chief Justice is for any reason unable to perform the functions of his office. A. Until a person has been appointed to and has assumed functions of that office, or B. Until the person holding that office has resumed the functions of that office, as the case may be, those functions shall be performed by the most senior of the justices of the Supreme Court. So clearly, this is a provision that allows for the most senior person or the most senior justice of the Supreme Court to assume the functions of the judiciary in the absence of the Chief Justice, or under circumstances where the Chief Justice is unable to perform his or her functions, or as is the case that the Chief Justice has been suspended. And clearly, when you look at the current standing of the Supreme Court, the justices that we have and who comes in as the topmost person, you would find that His Lordship Justice Paul Bafuboni, he's the senior most, followed by His Lordship Justice Gabriel Pwamang, who is also on this committee, which is going to look into these petitions seeking the removal of the Chief Justice. Following Justice Pwamang is Her Ladyship Justice Evel Lovelace Johnson. Following her is His Lordship Justice Isifu Imorotanko Amadu. And then we have Her Ladyship Justice Professor Henrietta Mensah Bonsu. We have His Lordship Justice Emmanuel Yoni Kolondi following. We have His Lordship Justice Samuel Kwame Esiedu following closely. And we also have His Lordship Justice George Kingsley Kumsin. Following him is Justice Ernest Yao Jehu. His Lordship Justice Henry A. Kofi. We also have His Lordship Justice Yao Dakwasari. And then finally, we have His Lordship Justice Richard Eji Frimpong being the youngest on the bench. So when you look at the standing of the Supreme Court justices, Bafuboni is the one who is the most senior after the Chief Justice herself. So even though no name has been given yet, we don't know whether it's going to come from the presidency, it's going to come from the Judicial Service. Like I did indicate from the beginning, the Chief Justice is also the head of the Judicial Service, and she belongs to that service. And I get the sense from what Felix is saying is the fact that the Judicial Service itself has its own way of announcing or naming whichever person is going to be the acting Chief Justice. But this is what the law provides under Article 1446 of the 1992 Constitution.
I see. Well, Justice Bafuboni has been at the Supreme Court since 2008.
Yes, that's about 17 years ago.
17 years now.
Yeah.
I mean, but if you do a quick recall of the petitions against Chief Justices of the Republic of Ghana and also the results, let me just put it on record that this is actually the first time we're having this process get to the point of a Chief Justice being suspended. It's a precedence. It's first development in our democratic history as a country, essentially.
Yes, Alfred, that's right. But it's not all gloomy as many may perceive it to be, because in the minds of many, this is already a closed matter where
the CJ is gone.
But that's not what it is, because we are still at a point where she's going through a process. It's only got to a point where there's a case for her to answer, and if she answers favorably, you can't tell what the outcome would be. For instance, if the committee returns or makes a recommendation that, yes, she's been able to answer favorably to the allegations that have been made against her, we will not get to a point where the Chief Justice will be removed from office. So, I mean, essentially, it's not all that's... It's not a closed case yet as many may perceive it to be. So let's just follow through the process and see what the outcomes will be, Alfred.
It's a very interesting point that you make, and then it sets the matters in context so that this process is going to flow. But then again, in time past, in previous cases of petitions against Chief Justices of the Republic of Ghana, it has not ever gotten to the point where a Chief Justice has been suspended.
No.
This is the development. This is the only one we are seeing that's gotten to this point where Article 14610A of the 1992 Constitution has been activated. If you look at from 1991 to 1995, the then Chief Justice Philip Edward Archer served within that particular period. There's really no record found of that. Isaac Kobna Aban also served as the Chief Justice of the Republic of Ghana from 1995 to 2001. There's really no record found of that, of any petitions. Then, in the case of the Chief Justice Edward Kwame Redu, who served as the Chief Justice of the Republic of Ghana between 2001 and 2003, Francis Janko Asasi Kofi was the petitioner in that particular case. What was the basis of the petition? Lying under oath about his date of birth, whether it was 1934 or 1932, it had to be determined. And also, he talked about deceiving Parliament during vetting to extend his tenure, and then committing perjury by providing false information to a public officer. When this was investigated, there was no prima facie case established, essentially.
So Alfred, when you look at all of these things, you realize that they all stem from the same allegation. I mean, to think that it was in respect of information that was provided and the context in which it was provided. That's how come you see the cases of perjury, you see the cases of false information before Parliament and all that. But essentially, they got to a conclusion that this petition actually failed. So we didn't even get to a point where the Chief Justice will have to be suspended, and then to make yes.
So that's one, and then the second we had, and this was quite popular at the time because Bright Takwete was a private legal practitioner like yourself, was then serving as an executive of the CPP at that point, and he petitioned against the George Kingsley Akwa, who was then Chief Justice of the Republic of Ghana, petitioned the former president, John Agyekum Kufuor, in that particular case. What was the basis for Bright Akwete's petition? Judicial interference, instructing judges on how to rule on specific cases, and abuse of office. He said, they said former Chief Justice George Kingsley Akwa was misusing his authority in judicial matters and then also victimization of judges. Then that particular petition also failed.
Yes, it also failed.
Essentially because really there was no case established against then Chief Justice. And fast forward, Georgina Tudor-Wood also had 2 petitions against her. She served as Chief Justice for 10 years. From 2007 to 2017. So guess what? That spans about almost 3 different administrations, right?
Yes,
because she was appointed by the former president, John Agyekum Kufuor. She served under the late John Evans Mills, served also in the first term of John Dramani Mahama until 2017 when she was then replaced. Okay, so 2 petitions against her. The citizens of La home and abroad petitioned her. The basis of their petition was that she was unfair in handling of the land cases related to the Gadangbe people. And you remember this Gadangbe land matter has been dragging to today.
Yes.
it's on. And in this case, the petitioner, one Ernest, let's go back a bit. One Ernest Obri Latte, a basis for the second petition was stated misbehavior and incompetence. And you read the 3 bases on which a Chief Justice can
this
be
likely
asked to vacate her position.
The basis for which you can ask for the removal of Chief Justice.
Stated misbehavior.
Yes, so all other things that have been stated here, like the way she handles the cases, will tie in into making a case under any of these, stated misbehavior or incompetence, and any of those things.
I see. So there was a then Justice Sophia Akufo, who is a member of the Council of State now, for John Dramani Mahama as President of the Republic of Ghana, was petitioned. Indeed, a petition was sent against her by Mensa Thompson of ASEPA. That's the former President, Nana Dankwa Akufo-Addo, who is her relative. This put it in context. Her relative was petitioned.
Exactly.
Right? And that petition failed, essentially. It was thrown out, right?
I like the context of, so you deal with this, and I'll just tell you something very interesting.
That see, afterwards, and let's go back to the Sophia Akufo, because her period, even though short, had some interesting and landmark cases as well that she presided over, and also left a lot for you lawyers to chew on within this period of between 2017 and 2019. That petition failed, but then let's look at the next who took over after Sophia Akufo. We see Justice Kwesi Anini-Yeboah, who the same Mensa Thompson petitioned the former President Nana Akufo-Addo against Kwesi Anini-Yeboah. That petition also failed because there was no prima facie case established against the allegation of $5 million bribery scandal by one lawyer against Justice Anini-Yeboah. That was thrown out as well. And then Gertrude Esabato Kono essentially has the highest in terms of the number of petitions that Chief Justices have, received or been petitioned
under the Fourth Republic.
Under the Fourth Republic. Yeah. 4 petitions against her, and that's the highest so far, at least since 1992. Professor Stephen Kwekwa comes in the latest, if you recall. That was just after the elections we got to know of it. The basis of his petition was that she overstepped constitutional powers in appointing justice to the Supreme Court, raised constitution of judicial panels and transfer of judges, usurping rules of court committee, and the judicial manipulation as well. What was the ruling on that? The conclusion was that that had no basis, essentially.
So the petition was actually dismissed.
The former President, Nana Akufo-Addo, threw it out.
So, Alfred, let me just point out something very interesting that's happening here. So you recall that a few weeks ago, there was also another petition against one of the Supreme Court justices, Justice Palmer. That petition has actually gone to the Chief Justice, who, as required by law, was supposed to determine a prima facie case or otherwise. Now, a few weeks later, that petition was withdrawn. Now we have a situation whereby this man, whose fate largely would have been determined by the Chief Justice, now becomes the chair of a committee that's going to look into allegations that are against the same person who, once upon a time or a few days back, was looking into matters that affected the now chair of this particular committee. This is just about the twists and turns of life and how fluid some of these things can be. At one point,
you are the one going to determine the fate of someone, and then the next moment, the person
may
is
have the
one
opportunity to also make a determination on
fate.
Exactly so, Alfred.
Interesting, they say that the life has many twists.
Precisely.
And, but earlier you mentioned the matter of who is going to act as Chief Justice, because the legal architecture hates vacuum, and that's why the provision that you read has made some steps available to be taken for an acting Chief Justice to be appointed. We're hearing from the cortesans of the presidency that there's a name that has just come up right now. Our presidential affairs correspondent Kamala Kluchi is joining us on the telephone. Kamala, what are you learning about the possible name of the acting Chief Justice that has been named as yet?
Well, no official communication, but what we pick up from the corridors of this administration is to the effect that Justice Bafo-Boni is to be acting as the Chief Justice, while Gertrude Tokono is going through the suspension and going through the process, whether she would be kicked out or she would be vindicated, whichever way it goes. But it cannot be void. That administrative process that she plays at the judiciary or as the head of the judiciary, it cannot be void. And so the next in line, which by convention has been the senior most, is Justice Bafo-Boni, who we understand would be acting in his stead. All of this is playing out as a result of that breaking news story that came in this afternoon from the seat of government concerning the suspension of a Chief Justice subsequent to the formation of that 5-member committee that's been set up to investigate her on the 3 petitions that have been sent to her. So yes, of course, even without it on the face of it, discussions have been to the effect that it's Justice Bafo-Boni who would likely be succeeding her in the event that she is found culpable of the various allegations that have been leveled against her. However, in terms of the convention structure of the judiciary, my understanding from the corridors of power is that some word has been put to the next senior most to be acting in her stead while she goes through the process.
See, but generally, how has the talk and the reaction been at the presidency where you are, in terms of the reaction to this particular announcement or the press statement from the government communications minister, Phyllis Kwachofoso, earlier today?
Well, if you talk to very ordinary people at the presidency who do not necessarily have any position of authority, they tell you it's long overdue. But if you're speaking to staffers, if you're speaking to, senior advisors, senior government people, they said, well, the president has absolutely nothing against the Chief Justice. In fact, many of them recall just when the president had won, the Chief Justice on many occasions was seen around His Excellency the President. The very last one was when the president met the diplomatic community and had dinner with them. I remember the Chief Justice and her husband were the very first to have even come to the venue before the diplomats even got there. Not too sure what the arrangements were, but it appeared that closeness was there until all of this thing, started making waves again, where she had to pull back. You would also recall during the National Economic Dialogue, she was there and sat very close to the president and all that. So the relationship, my understanding from senior members of this administration is to the effect that the president has no ill feeling about the Chief Justice. Is the process that he is just allowing her to go through in terms of fairness. Petitions were brought against her. Now there's determination by the Council of State that a prima facie has been established against her, which is not necessarily finality to the issue. She still needs to go through the process up to the final stage, whether she stands vindicated or she stands exposed, for want of a better word, in terms of being found guilty of the various offenses that have been leveled against her. And so it's all about taking her through the process, and the insistence is that at every material time they would do everything according to law and will not shortchange anything. It is to deepen the respect for the judiciary, the respect for due process as well, and also to allow for justice to be served in this matter.
Komla, appreciate you for this. Thank you so much for the latest coming through from the presidency. Our presidential affairs correspondent Komla Kloche there. Earlier, my colleague Joseph Akable spoke to Deputy Attorney General Dr. Justice Shremsai on this development as well and how the process will be going forward.
No, so there must be, I think we need to look at two things. There's an application for an injunction, and also there is the substantive case. Okay, what would constitute? I mean, the substantive case is still on, as far as I understand it, and there's nothing moot about it because the issue that the plaintiff has raised is an issue seeking the court enforcement of a provision, and so that is could be, which is that whether the Chief Justice should be given the petition, should be given a copy of the petition even before it is forwarded to the Council of State, So that issue will be there, and I believe it will be a relevant issue for the future in the sense that next time that there is any such petition, we will know whether it could be transmitted to the Council of State before the Chief Justice is given a copy. So far, and I don't know, so far the practice shows that every petition that has gone, to the Council of State had gone to the Council of State before a reference is made to the Chief Justice involved. Even the previous, petition which the former Attorney General, that Dr. Yabo Adami government superintended over, the record shows that it was forwarded to the Council of State before the Chief Justice was given a copy. So even though it's a strange proposition, we believe that a clarity from the court could be useful. In that case, the issue is not moot in respect of the merit of the case. For the injunction, the injunction is moot, but not because of the president's decision. It became moot the moment the Chief Justice got the opportunity and responded. That was when the injunction became moot as far as my understanding of the law is concerned. So if there's any mootness, it wasn't caused by the president going ahead to find a prima facie case or to suspend the Chief Justice. It became moot the moment the Chief Justice was given the opportunity to respond, and he indeed responded to the petition. So that was when it became moot.
On your mootness point, to the extent that in court documents, you argue strenuously that there is no law that requires the president to offer such a hearing. Would you not agree that that, to an extent, leaves the matter still open, that there ought to be some pronouncement on that, even if not in relation to the injunction, even a substantive matter itself?
That is what I said earlier, that there are two aspects. One, where the mootness comes in is when it's about the injunction. That is where the mootness comes in. But in terms of the merits, the substantive cases from the argument we have put before the court, it is not, even though, you see, even though it's moot, the court has heard that in future matters, that can also, so the court can still be here to prevent such a dispute arising in the future. So that's why I said earlier that when it comes to the merit of the case, it is not moot, but as far as the injunction is concerned, it became moot the moment the Chief Justice was given an opportunity to be heard.
And in terms of the considerations that the president undertook in terms of the process to come to the conclusion that, well, he should offer her a hearing, was it strictly based on what you had seen from the records in terms of how President Akufo-Addo handled those petitions that resulted in the decision to extend her hearing, particularly because of the fact that you make the point that no law from your arguments allows such a hearing to be extended to her?
No, you see, when the law says that every child is entitled to, let's say, for example, secondary education, okay? Or let me give another. When the law says that, if a law says that a person should not be kept, when they are arrested, they shouldn't be kept for more than 48 hours before being arraigned before a court. It doesn't mean that you should keep the person, for 48 hours. It means that if you can, even 1 second after arrest, you may take the person there. So the fact that we are arguing that the fact that we are arguing that there's no legal requirement that the CJ should be given a hearing before the document is transmitted, it does not mean that when you give a hearing to the person, you have committed or you have violated the Constitution. It only means that you have expanded or you have given more than the Constitution requires. So it's the same thing as saying that 48 hours. It doesn't mean that you should wait for 48 hours. It means that you should do it within the 48 hours. So that is the point. The fact that we have given, the president has decided to give the Chief Justice a hearing, before transmitting or before the committee speaks, does not mean that the president has done anything wrong. And the two arguments can still go together.
I mean, as a legal academic yourself, I mean, the question that I want to ask is, what do you make of suggestions that it is high time we need an instrument to regulate this particular procedure, given that a lot of it, the inroads have been made by way of judicial pronouncements?
Yeah, true. I mean, an instrument will raise a lot of the doubts and will make certain things clear. So, from where I sit, I think an instrument, a legislative instrument or constitutional instrument to further regulate this position, this process, could be very helpful in the whole. Could be very helpful. Yeah, so I agree with you. The other thing which I think we are dealing with is whether the suspension is necessary under the circumstances. When you look at the Constitution, whether or not to suspend the Chief Justice is a question. It's not automatic that whenever a prima facie case is found by the Council of State and the President, the Chief Justice should be suspended. However, there are other reasons why the Chief Justice may be suspended. So, for example, we have 3 petitions, right? And they are made up of allegations which we, the public, are not aware of. Now, the question is, if you have 3 petitions, you definitely will need a lot of time to prepare your defense and your explanation. So I think, playing the role of the head of the judiciary, both administratively and then judicially, is already a lot of work. And meetings are involved, and decisions are taken, and lectures and reading and all. That's a very heavy duty. So to put the Chief Justice in a position where we continue to perform these functions, and at the same time also be defending herself in respect of 3 petitions concurrently, that be probably one of the reasons why the president may want to suspend the Chief Justice, so that he would have sufficient time to prepare and defend herself against allegations. Another reason could also be, and I'm saying could because I'm not privy to what went on in the what informed the decision to suspend, but I'm only giving you some of the possible considerations. It could also be that elements of preventing interference with the inquiry. As you may know, the Chief Justice is the head of the judiciary and is administrative head, and all the Supreme Court judges are more or less subject to her administrative directives.
That's Deputy Attorney General, Minister of Justice of the Republic of Ghana, Dr. Justice Sremsai them. Now, if you recall, just about a week ago, Global Info Analytics also did a survey, put out the details, which we also discussed quite extensively on Ghana Tonight sometime last week on TV3. But the man who put this together and essentially detailing that 52% of the respondents were indeed in support of the attempt to remove the Chief Justice. There are others who had raised questions about the outcome of this particular survey. 18% of the respondents said they were neutral about this, said, attempts to remove the Chief Justice. 20% opposed, and 10% said they had no opinion. Musa Dankwa is joining us on Zoom right now. Musa Dankwa, appreciate your time. Good evening. Thank you for joining us here on Hot Edition.
Having me.
First off, I know after this, the details of this particular survey released sometime last week, one of the reactions is that the question that you asked them, a number of them did not even know, the details of the said petition, and so the outcome of this particular survey, 52% saying they're in favor of the removal of Chief Justice, would be a misplaced one because they were only just sharing their views in oblivion, not knowing exactly what the details of the petition against the Chief Justice was. Would you agree with that?
That is exactly what we asked them, Alfred. Let me say hello to your listeners. Now, you see, the fact that people don't like the poll did not stop the public from having their opinion. Our crime was just to bring that opinion into public domain. We are aware that the process that is being taken, she's been taken through, is legal process. And not many people understand the process. So we didn't ask them about the legality or otherwise of the process. They wouldn't understand those issues. But at least they know that the aim of the process will lead to either removal of the Chief Justice or leaving her in the office. That is not in dispute. So we did ask them a simple question, but this is how we framed the question. We told them that there are currently 3 petitions from Ghanaians asking for the removal of the Chief Justice, but no evidence of any impropriety has been made publicly yet. This is what we told the voters. And we asked them, do you support the process to remove her? We didn't ask them, do they support or do they believe it is legal or illegal or inappropriate? Just for them to give us their views on whether they support the process that has been initiated to remove her. Here, the essence of this question is to see people who will be objective, to say maybe let's wait and see the evidence before we support. But what did we see here? The poll showed that 52% of voters support the process to remove her without seeing any evidence. So the question is, people should be asking, why should Ghanaians, those educated, uneducated, wanting somebody to be removed without even seeing the evidence? That is the problem, and not the polls. Secondly, 20% said, no, we don't support it, but probably they haven't seen the evidence, or regardless of whether there's evidence or not, they won't support it. 10% did not have an opinion, and 18% were neutral. Now, we didn't end here, or we didn't end there. We went a step further to say, okay, now let's see those who will be objective. If there is evidence against her, would you still support the process to remove her? And this question was answered by those who had told us they didn't have an opinion, or they were neutral, or they oppose it. When we put this second question to them, then you have 30% of them now saying that, yes, they'll support the process if he's found to have broken the law. But 35% are still saying that, no, they wouldn't support the process. So they are saying that regardless of the evidence adduced against her, she should be left in the office. So these are the issues that people should be interrogating, and not the person who has not gone through the polls. So frankly speaking, there are those who, regardless of evidence or lack of it, they want her out. And there are those who, even with evidence, they don't want her out.
I see, but then let me understand this. Those who said they were neutral and those who said they had no opinion, what's the difference? In fact, because if somebody says I'm neutral on it, and another says I have no opinion on the matter, what makes those two positions different in itself?
Usually, the neutrals are maybe they have information a bit, but they haven't got enough information to make decision. So they kind of sitting on the fence. And no opinion, probably he hasn't got no knowledge about what is happening. So he has no opinion about the whole thing. So those who are neutral are normally sitting on the fence waiting for further and better information.
I see. But then I look at the regional breakdown of the respondents as well. That also tells a different story per region. As we see it, in the Western North region, we had 82% of the respondents saying that indeed they are in there saying they support the removal of the Chief Justice. What does that tell you? It's followed by the Volta region, 76%. I mean, what does that tell you?
You know, some of the figures tend to trend with partisan lines, because Western North, you will say that it's an NDC region. Western region, NDC won it, but most of them support her removal. Volta region, overwhelmingly 76%. Upper West region, about 49%. And then you have Savannah, 66%, OT 70% support. And Northern region, about 45%. Northeast, about 39% support. Greater Accra, 58%. Eastern region, 48%, still majority. Central region, 51% majority. Bono East, 72 majority. Bonos, 82 majority. Ashanti region, even 82 majority in Ashanti region. I mean, majority of 37% in Ashanti region. So you could see that mostly all the regions, except few, support the removal without even seeing the evidence. So what is informing this decision?
And now, hearing this particular decision by the president to follow due process and suspend the Chief Justice, setting up this 5-member committee to, as it were, follow the dictates of Article 146, it appears that the sentiment of the people are indeed playing out as reflected, is it not?
I don't expect the sentiment to influence the judicial process, because it is not an opinion issue. This is evidence-based and legal matter, and it's constitutional. So regardless of what people think, you must not follow public opinion. You must follow the law.
Mr. Dankwa, I appreciate you. Thank you so much for joining us. Mr. Dankwa is Executive Director of Global Info Analytics, and the details of that particular survey is on 3news.com. Make some time and visit 3news.com. We're back with the business news. Michael Obodo is standing by after this quick break. Stay with us.